Okay, so getting your estate planning done has probably been on your to-do list for quite some time now, and I understand. It's not a pleasurable topic, it's an added expense, and just something that maybe keeps getting put on the back burner. So let's talk about some helpful tips to help you find the right estate planning attorney for you. I'm Darcel Lobo. I own Dow Law Firm in Normandy Park, Washington, which is 15, 20 minutes south of the Seattle area. I've been an estate planning attorney for going on 17 years now, helping individuals, helping families, provide for their financial future, protect their assets, protect their kids and loved ones and families. So let's talk about estate planning and finding the right attorney for you. Let's first start with what your goals are. What are you trying to accomplish with your estate plan? Maybe some of you want to avoid probate. Maybe you have minor children you want to protect. Maybe you're thinking about planning for incapacity if that were to happen. Or maybe you don't even know. You know you need an estate plan, but you don't quite know what the goals and objectives are. That's okay, because you may not know what you don't know. And that's why you start with a consultation with an attorney to kind of talk about what you want, what that looks like, and they will help you figure out the goals and objectives and how to get there. So we first need to find you an estate planning attorney. And what does that look like? Well, a lot of times people will start with asking friends or family, someone that you know, like, and trust, to ask them for a recommendation, for a referral. So a lot of times clients will start there. Then also, you're looking online, right? You're looking for estate planning attorneys in your town, in your neighborhood, somewhere nearby to you. So you're going to be looking online, looking on Google, looking at their website, seeing what information they have on their website. What do their photos look like? Do they look like somebody you might want to work with? Do they look like they're somebody who's friendly and relatable and someone that you would feel comfortable sharing information with, right? Look at their reviews. What do their reviews say about them? If they have reviews online on Google, looking at those, see what people have to say. One note about that is that when it comes to not just an attorney or a professional, really anything, when it comes to looking for someone that has all 5-star perfect reviews, that isn't necessarily what you need. And know that anybody can go online and write a review, whether or not they were a client or not, right? And so I think the threshold, you want them to have at least maybe like a 4.4 on their review out of 5. So a 4.4, 4.5, anywhere up to a 5. I think somewhere in that range would be pretty good. As far as what kind of rating or reviews you're looking for when you're looking for an attorney, if you don't otherwise know them, right? If you're just looking online, you don't know where to start, and you're looking for an attorney, that's kind of the range that I would look for when looking for an attorney, or really any kind of professional service provider. I'd be looking somewhere in that range as far as reviews. Also, what's their experience? How long have they been doing estate planning? Is that their primary focus? Do they do a little bit of all different types of law? How long have they been practicing for? These are all different factors when looking at their experience. And so this information should be on their website. I think most state bar associations have an online directory that provides information about the attorney and if there's been any kind of discipline history against them. And so you can look there as well. If you're in Washington State, our bar association is the Washington State Bar Association, WSBA.org. You can go on there, go to the directory, type in the attorney's name that you're considering and seeing what the state bar has on them. And again, if there is any kind of discipline history, that will be there. Hopefully there is no discipline history on that attorney that you're looking for. And then when you're looking for an attorney and you're looking online, if you don't have a relationship, if you don't have someone that referred them to you, just remember that this is someone that you're going to be meeting for the first time. For a lot of you, it might be the first time you ever even met with an attorney at all. And you're discussing your assets with them. Someone who's a total stranger, right? You're telling them, this is what real estate I own. This is how much I have in the bank. This is how much my assets are worth. This is how much my retirement is worth. You're telling them all these things. So you want it to be someone that you're comfortable with talking those different things about, having those sensitive and confidential conversations, right? You want someone that you feel comfortable sharing that information with. And then also, I find value if again, an attorney or any provider is providing information out there for you to make an informed decision. Now, what do I mean by that? Like, do they write articles? Do they write blogs? Do they have any kind of PDF guide that kind of walks you through those options? Do they make videos? Do they have a podcast? Like, what information are they putting out? Because for a lot of my new clients in my consultations, like, they want information. Like, they don't know if they want a will or a trust. Why would they want one or the other? Do they need power of attorneys? What's in a directive? Like, they have all these questions. And so if the attorney is answering those questions already for you so you can make an informed decision, that's going to help you in that process. And to make getting your estate plan done a little bit easier, I think having the information really empowers you to make those decisions. And I think that's one thing that I will say a lot of my clients have liked about me, and what has brought them to me is that I write for a local blog. If you're local, then in the Burien area, we have the B-Town blog. I write for them twice a month. On my own website, I have a blog that I write twice a month. I have a lot of information on my website. I do have a free PDF guide that has information about estate planning. I am transparent about my fees. I have my pricing on my website. I make these videos. And so that way, when the new clients come to me, they already kind of have gotten to know me and what I offer and what I do and how I can help them. And I think that helps kind of humanize me as a lawyer. Like, yes, I'm a lawyer, but I'm also, a mom. I have 2 teenagers of my own. I have my own estate plan in place, and so it makes it a little bit less scary or overwhelming to know a little bit about the attorney that you're reaching out to, more so than just this is where they went to law school and this is where they went to college and they graduated cum laude. Like, though all those things are great, and not to take away from those accolades, but also like just to get to know kind of who they are. And even like I feel like in video like this, you can kind of hear me talk, see my mannerisms, and kind of decide like, okay, would she be the right attorney for me? And for some people, maybe I'm not the right attorney, and that's okay also, right? And so helping you decide who you want to work with, who you want to have that relationship with as a client, attorney relationship, and who you're going to trust to do your estate plan. So, all right, next point is their approach. Like, you don't want an attorney, at least I don't think you want an attorney, and I wouldn't want an attorney who's going to be really salesy and really pushy. I'd want to be comfortable speaking with them about what's going on and what my concerns are. I wouldn't want to feel rushed during the consultation. Are they trying to push some kind of sales pitch on me or upsell me? Are they trying to do all these extra add-ons? Like, you want to know what your options are and what the decisions are. And so we go over that. But it's your choice. You decide what you want to do and what you don't want to do. For some clients, a will package is a great package. For some clients, the trust option is a better package. There's pros and cons. We go over that and you make that informed decision. I'm not making that for you. I'm not trying to push you into one or the other. Now, each case can be different. There can be a reason that you want to go with one or the other. And so I will let you know that and suggest that to you. But again, it's your decision at the end of the day. And you don't want an attorney who's trying to push you into one or the other just because one might have a higher fee, right? And so you want to, again, it comes down just to your comfortability with that attorney, and how they engage with you, and if you feel like you trust them and trust their judgment. And I think this also takes us to another point is like the fee, right? And knowing the fee structure. Are they working on your estate plan on a flat fee? Are they doing it hourly, right? And so for all of my estate plans at my office, I guess with a few exceptions, but generally speaking, we do these on a flat fee. The ones that I don't do flat fees are the ones where I don't know how much work it's going to be. And that's usually when someone has an estate plan that they're bringing to me that they want me to review and update. I don't know if your will is going to be 6 pages long or if you have a 40-page long trust, right? And so for those cases, sometimes it is going to be hourly because I just don't know how much work there's going to be. But if you're coming to me for an estate plan from scratch, where we're doing a new estate plan for you, it's going to be a flat fee. And so you want to know that with the attorney that you're talking to about your estate plan is, what is it going to cost? Do they offer flat fees? Because it's a flat fee, you don't have to worry about the clock running, right? So if you're a flat fee with my office, if you call and have a question, you send me an email with a question, I'm not billing you for that. It's just the flat fee for my estate plan. If you have questions, you ask me, I'll answer them for you. You're not being billed for it. Now, if it's hourly, you are being billed for those things. And so for my hourly clients, I am billing for those communications and for the emails and phone calls and things like that. So if you want certainty of what it's going to cost you, you want an attorney who's going to offer a flat fee for your estate plan. Also, what is included in the fee? Like besides that fee, are you going to need to pay for anything else? Like for instance, if you do a trust package, if you own real estate, one of the things we have to do is title the real estate into your trust. And besides paying the legal fee for me to do that plan for you, you also have to pay the county the recording fee. You want to know all of that up front. So you want to know, what is my plan going to cost? Do I have any county recording fees? If we're doing an LLC for you in your estate plan, what is the LLC registration fees? You want to know what is it going to cost you all in. And so with a flat fee, you're going to know what that is. Again, we put our pricing on our website. They are starting prices or ranges, so you have an idea of what to expect. During the actual consultation, I'll be able to quote for you exactly what the fee will be, and then you can decide if that works for you or not. But the pricing guide that we provide gives you an idea of what the numbers are going to look like. Just know that I understand the concern about fees. I truly do. I know that getting your estate plan done is an added expense, and there are options to do it for cheaper. Sometimes, a lot of times, the cheapest option ends up being the more expensive option later. I have done many a will, many a trust where we have had to essentially scrap it and start over because it was not done properly. So there are a lot of forms online. You could Google right now. You can ask ChatGPT to draft you a will, and it'll probably draft you a will, right? But again, you don't know what you don't know. We're talking about your estate. We're talking about your real estate. We're talking about the assets that you worked so hard to build and acquire during your lifetime. We're talking about protecting your spouse, your children, your families, or whoever we're providing for. We want to make sure it's done right. And along those same lines, the cheapest attorney may or may not be the right fit for you. So again, aside from just your estate plan, this is someone that you're going to be working with, and again, divulging just really personal information. So you want someone that you're comfortable working with, and if that means it might cost more, that can be an added expense. And again, I understand that, but just know that sometimes you're getting what you pay for. And if we're talking about your estate plan, just really consider the value that the attorney is going to bring to you and to your estate plan and to your family. So keeping those things in mind, but again, being fully aware that estate planning is not cheap, and it is an expense. So, all right. Continuing on, communication. And I think a lot of these topics that I'm bringing up really kind of overlap with each other. I think this also comes back to the attorney you're looking for, but your communication with them, right? And so being able to have those conversations and talk with them and feel like you're being heard, feel like you're being understood, that they're taking their time with you. Now, every time you call their office, they may not be available, right? They have busy schedules. I have a busy schedule, right? And so between meetings and signings and hearings and court and all the things that come with being an attorney, especially if the attorney owns the law firm as I do, we can't always be available to answer the phone. But if you email me, I will respond to you. If you call and I need to call back, I will give you a call back. And when we are in communication, when we're talking, if you're in my office, like, you have my undivided attention. We're talking and I'm taking notes on what you're saying and what the plan is. And so you want someone that you feel comfortable to talk about your estate with, to talk about your family. Because sometimes clients come in and they end up telling me a lot about their families or spouses or falling out that they may have had with someone that they're close to, right? And so they're very personal things that Maybe you haven't told a lot of other people, and now you're having to tell this attorney that you don't know and you've never met before, right? And so you want someone that you can communicate with and that you have a comfortability there, and that you feel respected, and that they are there to help you and support you in achieving what your goals are with your estate plan. You want to be comfortable to talk with them and have those conversations. Can we talk about the number one mistake to avoid when it comes to your estate plan? The number one mistake that I see is continuing to put it off and to wait until later, to think that you don't need to get your estate plan done now, to think that it can wait until later. Not all estate plans have to be complicated. They can be very simple and straightforward depending on what it is that you want. But too many times, we are faced with looking at a probate where there wasn't a will, or the will never got signed, and where these things got put off. And so if you are in that boat where you have been putting it off, you've been delaying, I understand that. It's very important for you to get your estate plan done for everyone. If you're over the age of 18, you need an estate plan. Again, it can be simple. It doesn't need to be complex. Your will doesn't need to be 25 pages long. Okay? Please don't keep waiting. We want to get your estate plan done when you don't need it. That's the right time to get your estate plan done. If you wait until it's needed, it's probably too late to get the estate plan done, right? If you don't have competency, there's been some kind of, injury or illness, and you need someone to make decisions for you. Trust me when I tell you, you don't want to find yourself in the middle of a guardianship because you didn't do a simple power of attorney. You don't want your estate going through a probate without a will because it's probably not going to reflect what you want. If you don't have an estate plan, the state of Washington has one for you, and it may not be what you want. So please, let 2026 be the year that you get your estate plan done. Check that off your box. Check that off of your to-do list. On our website, I'll have it down below, I have our PDF guide that kind of goes over estate planning with our office and the 5-step process to get your estate plan done. I want to make it as easy as possible for you. I understand how difficult it can be again, so I want to make it as simple. There are some decisions that you're going to have to make, but I'm here to help you and guide you through making those decisions and getting that done. So again, make this the year that you get your estate plan done. Whether it's my office, whether it's another attorney's office, or if you're not in Washington State and you're somewhere else, find yourself an attorney, get your estate plan done. If this is helpful for you, if you like information about estate planning, you're not sure, you're trying to make decisions, I have so many videos on this page, I think over 100, about wills and trusts and power of attorneys, and talk about some real estate stuff and LLCs and all things related to estate planning, probate, and real estate. So make sure you stick around, subscribe, and I'll see you in the next one. All right, bye. Hi, I'm Darcel Lubbo. I'm an attorney and I own Dow Law Firm in Normandy Park. And today's question, we're going to be talking about kind of what the 3 main priorities of estate planning should be and what it is for most clients. So most of my clients have different objectives, right, and different assets, different family structures, but there are kind of some overarching priorities that all my estate planning clients have. The first one is really naming people that you trust to be in your estate plan, to be your power of attorney, to be your executor, to be your trustee, someone that you know and trust is going to follow your wishes and going to be able to manage that task at hand, to follow through with whatever you have outlined for them in your estate plan. Now, they are bound by what you have outlined, right? So they can't really make any decisions in that regards, but you still want it to be someone that you trust to serve in that capacity. They're going to have information about your personal affairs and your assets and debts. So someone that you trust to know that information, right? And also the person that you picked, you want to know that they're going to be able to handle your estate efficiently and effectively to manage your estate on behalf of who your beneficiaries or heirs may be. Now, even with an outline plan, whether it's a will or a trust, they can always reach out and contact an attorney to kind of help guide them, right? And so many times my office, we'll talk to someone who's been named executor, been named trustee, to help them kind of figure out, okay, what do I have to do? How do I do this? What are the steps that I need to take? And so they're able to have guidance as they navigate that journey. But you want to make sure that you're naming someone that you know and trust to serve in that capacity. Also, the kind of the next priority I would say that a lot of my clients have is making sure the distributions are made how they want them made, right? If you don't have a will, or if you don't have a trust or some kind of estate plan in place, the state of Washington, if you are a Washington resident, it has a plan for you. And it may or may not be the plan that you want for your estate. So by having your will in place or having your trust in place, you have clearly, defined who receives what goes where, and you don't have someone who doesn't know you, doesn't know your family, trying to make these decisions, right? And you want to ensure that the assets that you've worked so hard throughout your lifetime to acquire, you want to make sure it goes to the people that you know and you love, right? And that it goes to your family or close friends or other relatives, or if it's charities or whoever you want to provide for. You want to make sure the assets that you've worked so hard to acquire go where you would like them to go. And then also, I tell my clients all the time that having a well thought out estate plan, whether it's a will, whether it's a trust, that's one of the best gifts that you can leave to your heirs, is having a plan in place and not leaving a mess for your family to try and navigate and figure out. And so I know it's not a desirable conversation to have. None of my clients are really thrilled to be talking about what's going to happen when they pass, but we're all going to pass, and we should have a plan in place. And that's, again, one of the best gifts that you can leave to your family, is to have a very well thought out plan. And that's also going to help to eliminate any kind of disputes or challenges of your estate plan. Now, it's not a guarantee, and there's some things we can do in your estate plan to help assure that we're reducing the risk of any kind of disputes among, any of your heirs. But one key way to make sure we do that is to actually have a plan in place that outline what happens, what goes to who, and in what manner. And then thirdly, and along these same lines, the third priority most of my clients have is that they want to protect their assets. They want to maximize their estate. They want to reduce taxes. They want to reduce unnecessary costs associated with their estate. And with some proper planning in place, we can do so, right? And that's one of the factors that a lot of my clients have, is that, again, they've worked throughout their lifetime to acquire and to build their estate and their assets. They want to protect it as best they can, right? And so by having a plan in place, again, whether it's a will, whether it's a trust, and for each client, it's going to be maybe a little bit different based on what the assets are, the value of the estate, and kind of who your heirs may be and how you want to divide things up. But let's put that plan in place now and not leave it for your family to try to figure out on their own after you're not here. You want to make those decisions. You're the one who has acquired these assets throughout your life. And so you want to make those decisions. You don't want, a court or a judge who doesn't know you, again, doesn't know anything about your family, making these decisions as far as who's going to serve in what capacity and what's going to go where. So let's put a plan together for you. If you don't have a will, don't have a trust, and you need to do so, maybe it's been on that back burner on the back of your mind for a number of years. Some clients come to me and they say, we've needed to do this for the past 20 years and we haven't done it. But at least we're doing it now. At least we're getting a plan in place now. Or maybe you have a will that is quite outdated and we need to make some updates to it or start over again. So again, I'm Darcel Lobo. I'm in Normandy Park. I own Dow Law Firm. The phone number to my office is 206-408-8158. You can visit us online also at dowlawfirm.com, and I'll have that all below for you, so you can figure out how to reach us and to contact us if you would like our help. I am only licensed in Washington State, so if you are outside of Washington State, I would love to help you, but I cannot do so. I'm only licensed in Washington State. So if you're outside Washington, I would check with your state bar association or county bar association to get a referral for an attorney. But if you are in Washington State, I'd be happy to help you. All right, thank you. Have a good day. Hi, I'm Darcel Lovo of Dow Law Firm, and here we're talking to you today about common mistakes that I see with estate planning. Before we get into details, I am in Washington State, and so I'm only licensed to help individuals in Washington State. If you're outside of Washington State, thank you so much for watching. I appreciate you being here, but unfortunately, my office will not be able to help you. Hopefully, someone in your state or local county or city can help you with your estate planning. But whatever state you're in, let's talk about some common estate planning mistakes that I've seen to maybe hopefully help you or help someone else to not make these mistakes. So let's just get right into it. So the first one that we're going to talk about is naming a minor as a beneficiary. I've talked about this in other videos, but a lot of times maybe parents or grandparents will leave funds to a minor in a will. If someone is under the age of 18, in Washington State again, they are not competent to inherit anything under state law. So you cannot just leave funds outright to a minor, whether it's in your will, listed as a beneficiary on a bank account, on a life insurance policy. You should not be naming a minor directly to receive those funds because in Washington State, they are not competent to inherit those funds. So what's going to happen, depending on the amount, a court is going to open a guardianship for that minor to hold those funds. But it's actually a little bit more complicated than that because a guardianship is quite expensive because you have an attorney for the guardianship. The court is appointing a guardian ad litem to review the files. I mean, it's just, there's a lot that goes into it without getting into the details of it. But with just, some proper estate planning, that whole process can be avoided, right? So in Washington State, we really have two main options that I utilize for providing for minors. One is the Uniform Transfer to Minors Act, commonly called a UTMA account, where you're naming someone in your will or in your trust as the custodian of the funds for the minor. So let's say you wanted to leave something to your 4-year-old child, you would name someone as a custodian of those funds, and that person, those funds will be held in a custodial account for that minor, and then the custodian that you've named will be the one kind of in charge of those funds, but they be held until the minor reached at least the age of majority, which is 18. But I commonly recommend to my clients that they don't leave a lump sum to a minor when they reach 18, especially depending on how much we're talking about. Unfortunately, sometimes at 18, an individual is not ready to receive a large lump sum inheritance. So maybe age 21, 22, maybe 24, 25, maybe a little bit later before those funds are released from the UTMA account to the minor. Now, your other option is a trust for minors. We can do this in your will or in your revocable living trust, where we create a trust for that minor, or if you have multiple minors to provide for, we create a trust, for all minors that outlines when those funds are to be received by the minor. And with doing a trust, we can break it up into different increments over a longer period of time. And so depending on how much the minor is going to receive, maybe you want to break it up in halves or maybe in thirds. A lot of my clients, breaking it up into thirds at ages 25, 30, and 35 is very popular with a lot of my clients. And up until those points and in between those points of time, funds can be paid for the individual's, health and well-being and for education, things like that. But there's no lump sums being paid to that individual, to that minor, until they reach the ages that you specified, whether that's 25, 30, and 35 in thirds. If you want to do a large, just one lump sum at the age of 20, whatever, you can pretty much do whatever you want to do with the trust. But there has to be an end date. There has to be a point at which the funds are, depleted and given out to the individual who would no longer be a minor at that point. So at some point it has to end, but it gives you a little bit more control over how and when those funds are used. Okay, so that's mistake number one that we see in our office. Mistake number two that we see is not properly executing a will or a codicil. So I understand that for a lot of individuals, estate planning can be expensive. It can be an additional expense. We try to keep our fees reasonable. We share our fees for our estate planning on our website. So I'll link it down below, and you can see on our website what the cost is for a will package, for a revocable living trust package. But even though estate planning can be expensive for some, doing it incorrectly is a lot more expensive. Okay? If the will is not drafted properly, not signed properly, not witnessed properly, there are requirements here in Washington State for a will to be a valid will. If you don't have a valid will, then the court can defer to just what state law provides. And that might not be what you want the distribution to actually be. And so we want to ensure that your will is executed properly. If you go online and, find a will template, or you use some kind of document drafting service, you want to ensure that you are having it executed properly with the witnesses, with the proper attestation clause. Like, there's some requirements and formalities to a will that can get missed if you're doing it yourself. So I understand the cost-saving measure of doing it yourself, but just keep in mind that if it's done incorrectly, it's going to cost significantly more for your family, for your friends, for your loved ones, whoever may inherit from that will if it's not done correctly. All right. Number 3 is not keeping records about your assets and just really your financial affairs. So because not many times, but on more than one occasion, on a number of occasions, after someone's passed, maybe the family will come to me, and maybe there's a will, right? There's a will that says who receives what, but the family comes to me and they say, we don't know what the person owned. We have no idea where they banked. We have no idea if they had life insurance. We have no idea if there were retirement benefits. We don't know. And they come to me looking for these answers. And I don't know either. Okay? So there's no central database for assets. There is for debts, right? I can order a credit report to see what debts there were. But there's no asset report that we can pull to find out what all the assets are. So what do we do in that scenario? We're having to go through mail, go through all the files in the decedent's home. We're going through old tax returns. And that's really a lot of work for your family or your executor to have to do to try and piece these pieces together of the puzzle about what your estate even includes. So when we do estate plans here, for all of our estate plans that we prepare, whether it's wills or trusts, we prepare binders for our clients, and in the back of the binder, there's forms for the client to fill out to list where do they bank, who does their taxes, are there life insurance policies, are there retirement policies, what's your email login, what is your phone passcode. Trying to get access with the passcode to someone's phone, or trying to get email login credentials for someone after they've passed away, is pretty impossible to do. And so if you put this information together and include it with your will, with your trust, and it's not part of the will, it's just supplemental documents that we include in the binder that you fill out. So your family has that information. They know where to go. And so that all the assets that you worked so hard to acquire during your lifetime aren't for nothing. Because if your family doesn't know about it, doesn't know it exists, then they're not going to be able to claim it, right? So we want to ensure that when you do your will, when you do your trust, make sure along with those documents that you have information about your assets so your family knows where to go. And again, if you're inclined to do so, phone passcodes, email logins. Now, if you do all this, it's going to help your loved ones tremendously in your will. However, if you put these we do binders for our clients, so you can't lose your binder, right? You can't lose all these documents because it's such sensitive information, right? So you want to ensure you keep it somewhere that's safe and secure. If it's at home, whether that's in your safe at home, if it's at a safe deposit box at a bank, wherever you keep it, make sure the important people in your estate plan, your executor, your power of attorney, that they know where these documents are, that they know that they exist, and that they also have access to them. So make sure they have the safe combo, or make sure that they're named on a safe deposit box. Make sure that they have access. Okay. And then the fourth area of estate planning mistakes that we see pretty commonly, unfortunately, is waiting too long to do your estate planning. Procrastinating to get it done, putting it off, kicking that can down the road, and then suddenly it's needed. A power of attorney is needed for you, for whatever reason, right? Maybe it's short term, like a hospitalization, an accident. Maybe it's something long term, like dementia or Alzheimer's. And when it's time that you need an estate plan, it is too late to prepare your estate plan. The time to prepare your estate plan is before you need it. So if right now you feel like, oh, I don't need a will, I don't need a trust, I don't need a power of attorney, I'm too young, I'm healthy, I need to do that later on in life. No, the time to do it is now, when you don't need it. Because if it's needed and you don't have it, it's too late. I cannot do a power of attorney for someone who doesn't have competency to understand what a power of attorney is. I can't do a will if you don't have competency to understand what the will says, right? So when you need it, it's too late to prepare it. Okay, it needs to be done before you need it. Even if you don't think you need one now, it can be a very simple will. It does not need to be a complicated will. It does not need to be a complex process for you. If, your distributions and who you named, if it's simple, great. We'll prepare a simple will for you so that there's a plan in place. So that if a power of attorney is needed, if that will is needed, you've already taken care of it and it's already handled. Okay, so when someone comes to me, it's, kind of sad to have to tell someone that I can't do your will, and to have to explain to them that, there's an issue of your competency and being able to understand this document. That's a very rough conversation to have with someone, especially if there is a loss of competency, right? For them to understand why I'm saying that we cannot do a will or why I'm saying that we can't do a power of attorney. So please, if you think you don't need it yet, if you think that, you'll do it later on in life, I highly suggest that you reconsider and that you do this now and take care of this for your family and loved ones. Okay? So those are kind of the few areas where we see estate planning mistakes and kind of some suggestions from me on how to resolve those mistakes, right? So now that you have this information, you can then in turn take that and make sure your estate plan is in place, make sure you don't have minors named, make sure your will is executed properly if you did do it yourself or did it with a program, make sure it's done correctly, making sure you have all your asset information gathered for your family and loved ones in one place so that they know where to go. If you need help with your estate plan and if you're in Washington State, I would be happy to help you. Again, I'm Darcel Lobo. I own Dow Law Firm. I'll have our website linked below as dowlawfirm.com, or you can text us or call us at 206-408-8158, and we'd be happy to help you. Thank you. If you think that scribbling down your will on a napkin is going to save money and be just as effective as any other will, I want you to stop and watch today's video. I'm Darcel Lobo. I own Dow Law Firm. I've been an estate planning attorney for over 16 years now, and let's talk about handwritten wills. Now, here in Washington State, a handwritten will is also referred to as a holographic will. Those two terms mean the same thing. A holographic will is just one that's handwritten. So we're going to call it a handwritten will for today's video, just to simplify it and to not be confusing. So for a handwritten will, they are permitted in Washington State, but there are a few caveats to being able to do so. The handwritten will must be in writing and must be signed by the person making the will, and it must be witnessed by two people who are competent and disinterested. And what does that mean when I say disinterested? Your spouse cannot be a witness. Your child cannot be a witness. It cannot be anyone who is named in the will. That person should not be one of the witnesses for your will, and the witness actually needs to watch you sign it in live time. You can't sign it and have the witness sign it 2 days later. Like, they have to actually watch you sign it when you signed it. So there are formal requirements to being able to do a handwritten will. And if you've done a handwritten will and it's not witnessed properly, it is not going to be valid in Washington state. So for the will to be valid, it can be handwritten, it needs to be signed properly, and have 2 witnesses. That would presumably be valid. There's more to it than that, but for simplicity for today, that's generally what you need. If it's handwritten but there aren't 2 witnesses, it's not going to be valid. And also, when the witnesses sign, there's certain language that needs to be included for it to be what we call a self-proving will. And without getting into too many details, it's just going to make the process a lot easier for whoever is administering your estate to have a self-proving will, or else they may have to find themselves tracking down those witnesses who watched you sign after you've passed. And if this has been 5 years ago, 10 years ago, 20 years ago, trying to find those witnesses can be difficult sometimes. And so we want to have a self-proving will to avoid that need after you've passed. So some common pitfalls with a handwritten will is that they can be kind of vague. Like, it's not quite clear on what the person meant when drafting the will, what exactly the intention was. That could be a big one, a big issue that we see with handwritten wills. It's just not knowing what they don't know, right? And trying to do something. They're trying to do the right thing by writing out their own will, but it can cause a lot of issues for the family or the heirs down the road, which is also going to lead to an expensive probate dispute. Probate disputes are not cheap at all. They are very, very expensive, which is why when we prepare wills, we do what we can as best we can to make it very clear, to make it straightforward. And then also we include a no contest clause with our wills that says if anyone objects to the will, they're out, they get nothing. But aside from that, you don't want to cause confusion. The reason that you're creating a will is to provide clarity and a roadmap as far as what you want to have happen. So we want that to be clear. We don't want it to be confusing. If you have a will from out of state, as long as that will complies with that state's requirements, even if it's different than Washington, Washington will honor it. And so if you have a handwritten will, or you know someone who's done a handwritten will, it's probably worthwhile to have them consult with an estate planning attorney to talk about the will and to maybe make sure that they have one that's done correctly and that's drafted properly and signed properly and witnessed properly, just to avoid any kind of headaches and time delays and high expenses down the road. So you can give us a call at 206-408-8158. Thank you. Hi, I'm Darcel Lobo and I own Dow Law Firm, and today we're going to talk about estate planning. For a lot of people, when we talk about estate planning, people think that, I don't need to do estate planning. I can wait until I'm older. I don't have enough assets to think about estate planning, but that's really not true. Estate planning doesn't have to be complicated. It doesn't have to be expensive, but everyone should have a plan in place for what happens, whether it's, upon your passing with a will, whether it's, upon your loss of capacity, whether it's short-term or long-term. Most commonly we see that like with Alzheimer's or dementia. So you need a power of attorney. So having these documents in place is really important for everyone to have, and waiting until you need them is too late. If you don't have the capacity to sign something and to understand the document, then we can't prepare that for you. We can't do a power of attorney. A lot of times we get a call about somebody who either has dementia or is in the hospital and they need a power of attorney, but it's too late at that point in time. At that point in time, you're looking at a guardianship for that person, which is quite a cumbersome court process sometimes. It really can be. And so if we can just put a few documents in place really for a simple estate plan, whether it's, your will, your healthcare power of attorney, your financial power of attorney, and your directives, that's all we need to have a simple estate plan in place and to have a comprehensive plan in place. And it's for you, but it's for your family, it's for your loved ones, it's for your spouse, for your children, for anyone else in your family or friends or loved ones that you want to leave something to, or who you would trust to make decisions for you. We want to have that plan in place for you. And so today's video is talking about estate planning, the importance of it, and why you would need it. And so, as I mentioned initially, everyone should have an estate plan. It doesn't need to be complicated. It can be simple. It could be pretty straightforward. For a simple estate plan, we're looking at a will, power of attorneys, and directives. And we try to make it as easy as possible. You contact our office, we'll schedule a consultation. You'll meet with me, whether it's by phone, by Zoom, or in person if you prefer. My office is in Normandy Park. We'll talk about what your assets are, what you want your estate plan to look like. I'll gather information from you, and then we start preparing your documents for you. And within usually about 2 to 3 weeks, we have drafts ready for you to review. I mail the hard copies for you to review the drafts, or I have a secure online portal that you use to review your drafts. Once you've approved them, we schedule a date and time for you to come back to my office where we notarize and witness those documents and get them signed for you. For a lot of my clients, getting their estate plan done is something that's been on their to-do list for a really long time, usually for years. A lot of times clients will come to me and their children are adults, their children are grown, and they'll tell me, we wanted to do this when we had our kids, 20, 25, 30 years ago, and we never got around to getting it done, but we're so glad that it's done now. It's such a relief to know that this one thing that's on your to-do list, it's been on your to-do list maybe for a really long time, but it's been on the back burner. It hasn't been a priority. But again, we don't want to wait until it's needed, because then it's too late. It's too late to get a plan in place for you and for your family. And so getting a plan in place now, when you don't need it, this is a time to do it. And I know that it's not a priority always. I know it's not a pleasant conversation to think about what happens upon our passing, or what's going to happen if we lose capacity. It's not a pleasant conversation. It's not one that, most clients want to have, but it's a necessary one. It's one that you want to be the one in charge of making those decisions for yourself. You don't want a court or a judge making those decisions for you, who doesn't know you, doesn't know your family, and is trying to decide what's best for you. You want to be able to decide that for yourself. And the great thing with estate planning is that it's not set in stone forever. If you ever want to change something, if you name someone as your power of attorney and 5 years from now you don't think that's the right person anymore, we can change it. That's no problem. Once we prepare the estate plan, it's very easy for us to go in and do short addendums to update things and to update documents and make changes, because as life goes on and your assets change and the people in your life may change, and so you want to make those updates so you know that you can make those updates as you need to do so. And so as far as your estate plan, it could be something as simple as a will, power of attorneys. It could be a little bit more complicated if you want, not complicated, let's say a little bit more detailed, a little bit more thorough or complex if you want to do something like a revocable living trust. Depending on your size of your assets, we might want to take up another step and do some tax planning. But again, there's different layers of estate planning. You don't have to do everything at once, but we want to at least have a plan in place for you. It's, we're now have started 2024. It's the first week of January. A great time to get one of those things off your to-do list at the beginning of the year. If you contact our office, now we get you scheduled in the next week or so. We can have your estate plan done in the next 30 days. And it's something that you can take care of, get it off your to-do list, and not have to look at it again. And so in doing your estate planning, I just, as someone who, I have 2 small children, I have a spouse, and just knowing that, there's a plan in place for all of us. If something were to happen to just me, or me and my spouse, or to me, my spouse, and my children, to know there's a plan in place, because it's very devastating for a family when someone has passed away. They're already having, they're grieving the loss of that person, but there's no plan in place. There's no will, there's no trust. The family doesn't know, what all assets there are, what investments there are, what insurance policies there are, what bank accounts there are. They don't know anything. There's no plan in place. That is so difficult to navigate that legal process when you're grieving the loss of someone that you loved. And so having a plan in place is really one of the best gifts you can leave to your family and to your loved ones, is to have a plan in place. And so again, we try to make it as easy as possible for you. There are some necessary steps in that process, but we are here for you through that process from start to finish to take care of everything for you and to answer your questions for you and to be here to guide you and support you, as you're making these decisions. And again, it doesn't have to be set in stone. If you ever wanted to make changes, you just give us a call and let us know what changes you want, and we're happy to make them for you. We've already prepared the original documents, and so we just go in and make those addendums. So if getting your estate plan done is one of those things that are on your to-do list for 2024, or if it's not on your to-do list but you've now realized that it probably should be, or maybe you have an estate plan, maybe you have a will, but it's 20 years old and your children were minors at the time and they're grown and you have grandchildren, and maybe your assets have changed, and you're just thinking to yourself that, you know what, I probably need to find that old will and see what it says and probably make some changes. Well, give us a call. We're here and we're happy to help you. I offer my consults by phone, by Zoom, or in person, whatever's most convenient for you. I'm in Normandy Park, which is in kind of the South King County area, not too far from the airport. If you are outside of Washington State, we get a lot of calls from individuals who watch the videos from all over the country and the world, and I appreciate you. Thank you. But I am only licensed in Washington State. And so if you're outside of Washington State, I would suggest to contact the Bar Association for your state to find an attorney who can help you with your estate plan. But if you're in Washington, I can help you. I'm happy to help you. Give us our office a call. Our number is 206-408-8158. I'll have our website listed below. You can call us or text us, and we're here and happy to help you. Thank you. Hi, I'm Darcel Lobo, and I own Dow Law Firm in Normandy Park, and today we're going to talk about what to do if you don't know who to name as the personal representative or executor of your will, or as successor trustee of your revocable living trust. With both options, we need to pick someone who you trust to administer your estate, whether you're going to use a will or a revocable living trust to handle your affairs. Now, if you're married, it's going to be your spouse. But what if you're not married? Or what if your spouse predeceased you? Sometimes I have clients where even though they have children, maybe they don't want to name their children as the administrator of their estate in whatever capacity they'll be serving. They don't want to name a child. Maybe that child is not good with money. Maybe they have multiple kids and are concerned about the kids fighting or there being any kind of dispute, and they want someone neutral to be in charge. But they don't have someone to choose. They don't have someone else to name. Or maybe there's no spouse and there's no children, but they don't know who to name. Now, you can name a friend, you can name another family member, but for some clients, they can't decide. They don't have someone in mind to choose to serve in that capacity. And our office does not serve in that capacity. So I'll be your attorney to prepare your estate plan and to assist with it, but I will not serve as the trustee or as the executor of your estate. So what do you do? Who do you name? Well, in these instances, I discuss with my clients naming a professional executor or a professional trustee. There are professional fiduciary companies that will act in this capacity and administer your estate according to the terms of your trust or according to the terms of your will. Many banks will also serve in this capacity. So if you have a bank that you've used for a long time, that you have a relationship with and one that you trust, we can inquire with that bank as to if they serve in fiduciary capacities. Now, some banks, if they do offer this service, sometimes they have minimum requirements. Sometimes they require that you actually are a member with their bank. So I want to figure out what are their requirements, what are their rules for serving in that capacity, and also as important, what is their fee? Because they're not going to do so for free, right? It's usually going to be a percentage of your estate, is going to be the fee the trustee charges. And it's probably going to vary depending on how complex or simple your estate is and how much long-term management your estate may need. Now, some institutions can be expensive and some, not so much. Some are more reasonable. So it's important that whoever you decide, if you decide to use a professional trustee or a professional executor, that you understand how that fee structure works if you're going to go with that company as the fiduciary for your estate. Now, many times they won't act as power of attorney. So you have to figure out exactly what capacities will they serve in and how can we include them in your estate plans. And so usually when you let me know who you've decided as far as a professional company that you want to serve as your fiduciary, I will reach out to them and figure out how do we properly name them in your estate planning documents. For some banks I already know, I've worked with them before, but we will check with them to make sure that we have them named properly. And so that is something to consider. If you feel unsure, if that is stopping you from getting your estate plan done, that you don't know who to name, well, we can solve that problem. We can get your estate plan done by naming a professional corporation to act as your fiduciary. And again, you can always change it. So if you name a professional fiduciary now, but maybe in a few years from now you decide that there is someone that you do want to name, we can always do an amendment or a codicil to your trust or to your will to make that update and make that change for you. So it's not set in stone, but don't let that prevent you from getting your estate plan done if that's been the reason you haven't gotten that done. It's so important that we have a plan in place for you. No matter how simple, no matter how complex, we want to ensure there's a plan in place. So if you need help with your will, if you need help with your revocable living trust, feel free to give our office a call. We'd be happy to help. You can send us a text as well. Our number is 206-408-8158, or you can visit us at dowlawfirm.com. We'd be happy to help you, and I will link our contact information below. Thank you and have a great day. Okay, so let's say you've done your will, your trust, your power of attorneys, your estate plan, and someone that you've named in those documents has had a name change. What do you do? Do you need to redo your documents? Do you need to do amendments? What happens? Today we're going to go over that and kind of in detail and explain that to you. The short answer is no. You don't need to redo your entire estate plan or even do an amendment just because somebody had a name change. Most commonly, we'll see name changes with like a marriage or divorce, things like that, right? And so as long as that person can still prove that they are that same person that was named in your documents, it should be fine. So they need to keep a copy of their name change order, again, marriage certificate or divorce decree, something showing that they are still that same person. And if it's someone like your child, right, they can show proof that they are your child with their birth certificate, showing like, yes, this is me. I am my mom's, daughter. I've had a name change. Here's, my maiden name. Here is my new name now, my married name, or, whatever the reason for the change may be. I get calls sometimes of people worrying that they have to redo their estate plan because of a name change of someone that's named in their documents. Maybe the person is their power of attorney. Maybe it's the executor of their will. Maybe it's the guardian of their children. We don't need to for those purposes. Now, if you want to do so, you certainly can do so, and we'd be happy to help you with that. But I'm just here to, eliminate any cause for concern, any sirens that might be going off that you need to update your documents due to a name change. Now, if you have had a name change, and again, if this is because you got married, then it's probably time for an update to your estate plan due to the marriage, right? If your name changes because you got divorced, it's probably time to reevaluate your estate plan after that divorce because your ex-spouse is probably named in your estate plan, right? And so when we're doing updates due to a marriage or due to a divorce, then we're usually doing updates anyways because of the new spouse or because of the ex-spouse. And so Again, just with those changes as far as names of someone that you've named in your estate plan, probably don't need to redo your estate plan, probably don't need to do an amendment, but if you want to do so, if you want to just keep things current, we certainly can do so. But if you have had a name change in since you've done, again, your will, your trust, your power of attorneys, then we probably need to look at your estate plan just in general for what updates are needed because of that life event that you've had, right? If you've had a marriage, if you've had a divorce, you're probably looking at some updates to those documents anyways. So if you need help with updates to your estate plan, if you don't have an estate plan and you're looking to do one, estate planning does not have to be difficult. It does not have to be complicated. One of the things that I really pride myself on with my estate planning is that I try to make it simple as best I can. Sometimes clients do have more complex situations, but I want you to understand what your estate plan says. I can't tell you how many times somebody will come into me wanting some estate planning updates. They have a big binder of a whole bunch of documents and they have no idea of what their estate plan says. I've had people come to me where the estate plan says something and it's not what they want. They didn't realize that that's what it said. So we want to make estate planning simple. I want you to understand what your estate plan says, and I don't want it to be scary. The consultation is very easy. We do it by Zoom, we do it by phone, we do it at my office. You're meeting with me for that consultation. We're going over what you want. I'm helping to guide you, helping to answer questions. Once we figured out what it is that you want, then we get to work. We start drafting your documents for you. Then we get them to you for you to review. You approve them. You come to my office and we sign them. We provide the notary. We provide the witness. We do all of that for you to make it as easy as possible for you. And then when we deliver your documents to you, we give you a binder that has all of your originals. You keep your originals. We don't keep them. But also we're providing information for your family, for your loved ones, as far as what to do when someone passes, important resources, important phone numbers. And then also in the back of the binders are forms that you can fill out that says, who does your taxes for you? Who's your financial planner? Where do you have life insurance policies? Where do you have retirement policies? Because trying to figure out that information after someone's passed can be pretty difficult. So we want to do as much as we can to make it easier for your family and for your loved ones. And I'm here to help you make it easy for yourself and for your family. So again, if you need help with your estate plan, reach out to us. We're happy to see if we can help you. I'll have our number and website linked below. All right, thanks. Hi, I'm Darcel Lobo and I own Dow Law Firm in Normandy Park, and today we're going to talk about a no contest clause, what it is, why you would want one, how you would use it. So within a no contest clause, this would be a provision that's either in your will or in your trust, it's in your estate plan, that essentially says if anyone disputes my will or my trust, they're out, they get nothing. Now, in prior years, it used to be more common to leave someone like $1 to disinherit them or otherwise not provide for them. You don't need to do that anymore. You can just disinherit someone from your will or trust. But even if you're not disinheriting someone, if you just have reason to think that there may be, some dispute, some question about your estate plan, especially if you're not treating everyone equally. So if we have an estate plan where everything's being left to the children equally, there's usually not going to be anything that gives rise to a dispute or for someone to contest something in your will or your trust. But if we're treating individuals differently, different distributions, not providing for someone or providing a lesser amount for someone, you may want to consider having a no contest clause in your will or in your trust. That will help to disincentivize anyone in your will or in your trust, or who may otherwise be entitled if they were disinherited, from disputing or contesting your will or your trust, because what it says is that that person gets nothing. So if you left them a lesser amount, if they contest it with a no contest clause, then they're going to look at getting zero potentially instead of the lesser amount. So it really helps to disincentivize. It's not a guarantee that no one will contest the will or trust, but it will highly discourage someone from doing so. So if you're doing your estate plan, if you're looking to do your will, do your trust, maybe you need to update and review those documents. Maybe it's been a while since you had your will or trust drafted. You'll want to look and see if you have a no contest clause. And if you don't, and if you want to either update or revise your will or trust, then you may want to consider asking your attorney to include that in those documents for you. So again, I own Dow Law Firm. I'm Darcel Lobo. I'm only licensed in Washington State. So if you are in Washington State and you would like assistance with your will or trust or your overall estate plan, we'd be happy to help you. Unfortunately, if you are outside of Washington State, I am not licensed outside of Washington, so I can't help you. You'll want to look for an attorney licensed in your state. Your state bar association should be able to give you a list of attorneys in your area who can assist you. So I hope this helps. And again, if you're in Washington and want help with your will, with your trust, give our office a call. Our number is 206-408-8158. Thank you. Hi, I'm Darcel Lobo and I own Dow Law Firm in Normandy Park. And today's topic, we're going to talk about leaving an estate to a minor. Now, what does that even mean? This is when either in your will, you've named your minor, whether it's a child, grandchild, someone who's under the age of 18 to receive something from your estate out of your will. Or maybe you're naming a minor as a beneficiary of a life insurance policy or some other kind of financial account. We're going to go over why you should not do that. Okay? Do not leave anything to a minor outright. So let's get into why. So, and again, I'm only licensed in Washington State, so this is information for you in regards to Washington State. And so if you're outside of Washington State, you'll want to talk to an attorney in your state to confirm what the options are for you in that state. But for Washington State, that's what we're going to discuss. Here we go. So, under state law, a minor is not competent to inherit anything. Okay, so even if you named your child as a beneficiary of a life insurance policy, they're not going to just receive that money outright if they're not over the age of 18. Okay, so in that scenario, depending on how much the funds are, there could be a whole guardianship opened for that minor to handle those funds if you've named a minor and you've passed away. Okay, so the court's going to get involved. It's a very time-intensive process. It's a very expensive process, and it really limits how those funds can be used or invested on behalf of the minor. So with some small steps and some proper planning of your estate plan and your will or in your trust, we can avoid all that from happening. Okay, so if you want to provide for a minor, we can do so, but how do we do so? We don't do so by naming them outright as a beneficiary or naming them in the will directly. There's the two main options that I use with my estate plan. One is a Uniform Transfer to Minors Act that we have here in Washington State. This allows you to designate someone as a custodian to manage assets on behalf of that minor until they reach the age of majority, so at least 18. I believe it goes up to age 24 or 25. My memory is not serving me correctly, but it's between 24 and 25, those funds can be distributed to the minors. So you can say, pursuant to the Uniform Transfer to Minors Act, I want, this beneficiary to receive $50,000, but not to receive it until they're age 21. I'm appointing John Smith as a custodian of that account. That's not verbatim how it will read in the will or trust, but that's essentially what it says. You're naming someone as custodian of those funds to be in charge of those funds for the minor until the minor reaches a certain age. Again, at least 18, I think up to 24 or 25. My memory, I'm kind of blanking right now, but it's between those two ages. So that's option one. That's the simplest option. The second option is not that it's not simple, but it's a little bit more wordy in your will or your trust than using the Uniform Transfer to Minors Act. So that's creating a trust for minors. This allows you to designate someone to be the trustee of the trust for a minor and have more, I would say, strings attached to that inheritance for a minor. Okay, so you're naming someone in charge. You're specifying what age you want the minor to receive those funds, but it doesn't have to be one lump sum at one certain age. And it could be longer than the age 24, 25 that the Uniform Transfer to Minors Act allows. So you can do age 30, you could do age 40. At some point, that trust for the minor has to end. It can't continue indefinitely. But for a lot of my clients, and it's going to depend on how much the minor is set to receive. But for a lot of my clients, they really like a 25, 30, 35 split, where it's broken into thirds. And the minor gets 1/3 at the age of 25, the second third at the age of 30, and the last third at the age of 35. I find that allows a minor to not blow through their inheritance, hopefully. It gives them multiple kind of bites of the apple to, use the funds more wisely. And at those ages, 25, 30, 35, maybe they're getting married, maybe they're starting a family, and so you're providing for them in their future and really protecting the funds to hopefully, not have them be just depleted immediately if you were to leave one large lump sum. Now, again, it's going to depend on how much you're leaving the minor, so that's going to affect the distribution schedule as well. For some smaller distributions, it might not make sense to break it up into thirds, but for larger distributions, it makes sense for a lot of my clients. And then also, aside from the 25, 30, and 35 distribution, in between or even before those ages, the trustee you named in that trust can provide for the minor's, health and education and well-being throughout. So if funds need to be paid to care for the minor, that can be used, but the minor is not receiving any outright lump sum distributions until they reach the ages that you specified in that trust for minors. So again, the trust for minors kind of gives you more control, lets you place some more strings that to attach to that distribution versus the Uniform Transfer to Minors Act. So those are the two options that I primarily use with my clients when we're providing for minors. Again, it could be children, it could be grandchildren, anyone who's under the age of 18 that we want to provide for. So again, I recommend, even though an 18-year-old is competent under state law to inherit, usually I don't encourage my clients to leave a large lump sum to someone at the age of 18. Now, ultimately, it's the client's choice. I'm here to give you my advice and to guide you and let you know kind of what your legal options are. But if you tell me, Darcel, I want my child to receive the lump sum at age 18, I'll discuss pros and cons with you, but it's your will or it's your trust. So we're going to do what you want to do as long as it's valid and legal. I want to make sure that you are making a well-informed decision when it comes to your estate plan. Okay? So I hope this helps. If you need to provide for a minor, if you currently have a minor listed as a beneficiary of an account and you want to get a proper estate plan in place, you don't want that minor to have their funds go through a guardianship, give our office a text, give us a call, give us an email. We're here and happy to help you. Again, we're limited to practice in Washington State. So if you're outside of Washington, I would not be able to assist, unfortunately. But if you're in Washington, we're here and happy to help. The number is 206-408-8158. Thank you. Hi, I'm Darcel Lobo. I'm an attorney here in Seattle, and I own Dow Law Firm. And today we're going to talk about what to do when a spouse passes away. And this is primarily targeted to the survivor spouse, okay? And I'm making this video because there's been a number of occasions where I have a client come to me and a spouse has passed away. And a lot of times, maybe in a marriage, there's one spouse who handles the financial decisions, right? Handles the income, handles the investments, pays the bills. And if that spouse is the one who passes first, the survivor spouse sometimes has to figure out what to do with the finances. And these are sometimes immediate decisions that have to be made and figured out, right? And so the spouse is grieving the loss of the spouse that passed away, while simultaneously having legal issues, right? And having to figure out how to pay bills, what bills to pay, and how to handle various income sources and investments and bank accounts. And it's a lot. And so let's just kind of talk about and walk you through what to do, some initial steps, and how to get help, and just some kind of general guidance. Now, this video is for those of you who reside in Washington State, because I'm only licensed in Washington State, and that's where I'm speaking from, especially since we are a community property state that is unique to Washington. There's a handful of states in the country that have community property laws, but not all of them. So if you're not in Washington State, I'd encourage you to talk to an attorney licensed in your state. If you are in Washington and you want some help kind of navigating what to do if a spouse passes away, this video is for you, and let's continue on. So we first want to understand community property. Community property in Washington State presumes, for the most part, that assets acquired during a marriage, whether they're in one spouse's name or the other spouse's name, belong to the marital community. Now, there are a few exceptions to that. So, of course, if you brought assets into a marriage and those are separate, if you had a prenuptial agreement that identified separate assets, if during the marriage you had an inheritance from someone, that's separate property unless you've commingled it and made it community property. Personal injury claims can be separate property. So there's a few exceptions. And so the first step is to kind of figure out, well, what's community and what's separate? For most of my clients, everything is community. For a lot of my clients who've been married for many years and the assets were acquired during the marriage, and if they're not already in both spouses' names, they would be deemed community property assets. So let's talk about some initial first steps. When a spouse has passed away, you're going to notify the financial institutions where that spouse had an account to let them know that that spouse passed away. But when you do so, depending on if it's an investment account or a checking or savings or some kind of credit account, like a credit card or a line of credit or a loan, the financial institution may freeze or close that account. So you may not have, especially if it's a credit account, like a credit card or a personal loan, that account will probably be frozen and probably closed. And while that can be inconvenient for the survivor's spouse, it's done to protect the decedent. Because unfortunately, we've seen a high number of instances of fraud where someone will, someone that's unknown to the decedent will incur a bunch of debt in that decedent's name and rack up debt and credit in that decedent's name. So they freeze and close the accounts to prevent that from happening. So just know that when you notify them about, again, on a credit card or a loan, that account may be frozen or closed. Now, if you are jointly on that account as well, that may not be the case. They may not freeze and close it because you're also on the account. They may be able to just remove the deceased spouse's name, but just be prepared that that could happen. Okay, so for bank accounts, for your checking and savings account, if you were both on that account together, you should be able to go into that financial institution and have your deceased spouse's name removed. Again, if it was acquired during the marriage, if it's community property, you should be able to provide a death certificate and have that spouse's name removed from the account so it's only in your name. This usually is easier with a more local bank, like a credit union. It's usually easier because they're more familiar with Washington State laws and community property laws. Sometimes your bigger banks, your national banks, you may have a more difficult time with because they are not as always well versed in Washington's laws and community property laws. If you have a community property agreement that says what's yours is mine and what's mine is yours, which is kind of the short of what that document says, that should make things a lot easier for you. If you don't have that, if you have a will or a trust that says everything goes to my spouse, that should resolve that. Or if you were named as beneficiary to your spouse's account, then that would resolve that. With a will, or if there is no will, no trust, no beneficiary, you're not on the account, you may find that the bank says, we need letters testamentary. And you're left to figure out, well, what is a letters testamentary? This was my spouse, this was our money. A letters testamentary is what you get when you open probate. Now, I try to help all my clients avoid probate when one spouse passes, because if everything is community property, in most cases, we should not need a probate. But there can be some circumstances when a probate is actually needed for a survivor's spouse. Now, if we do proper estate planning, then that should not be needed. But if there's not an estate plan, a lot of times clients will come to me after a spouse has passed and said, we wanted to get a will done, we wanted to get our trust done, we never got around to it. Then the spouse passes, and then the survivor spouse kind of has this little bit of a mess on their hands when it comes to the finances that we have to sort through and clear out. So we try to avoid probate, and in most cases we can, but sometimes we can't. And that's really going to be on a case-by-case unique basis. So if you need some help with that and analysis, if you need probate or not, that's more suited for a consultation with my office for me to kind of assess what's going on, what the assets are, and if you need probate or not. So after sorting through the initial finances and straightening out the bank accounts, the investments and retirements and life insurance policies and Social Security, there's a lot to be done when someone passes away. But so once we sorted through all of that, then we want to look at updating the survivor spouse's estate plan and updating their beneficiaries and their power of attorneys and their will or their trust, because a lot of times it had the survivor spouse named. But if that survivor spouse has predeceased you, well, then we need to look at, okay, well, who else are we going to name? Where is everything else going to go? Who do you want to be your power of attorney? Who's going to make decisions for you? And so we're a lot of times looking at updating those documents as well after a spouse has passed. And again, once we've gotten all the finances sorted out and gotten all the assets into the survivor spouse's name, and also real estate. I didn't mention real estate, but if we have both spouses on real estate, there's a couple things we can do to remove the deceased spouse from title. You'll want to do that as a surviving spouse and make things easier for whoever's going to inherit the estate from you upon your passing. If it's going to maybe your children, for instance, we want to remove the deceased spouse from title. If you already have a trust for your estate plan, we don't need to do it in that situation. Your trust should already provide for what happens upon the second spouse to pass. But if you don't, we're going to want to look at removing the deceased spouse from title to make things easier in your estate. Also, I want to mention that if you did have an estate plan and the first spouse passed away, if you did any tax planning, you may have some time restrictions to utilize that tax planning in your estate plan. You usually have 9 months from the date of this first spouse to pass to take advantage of the tax planning in your estate plan. And so if that's the case, you want to make sure you talk to an attorney to do that planning within those 9 months from when the first spouse passed away. So we've gone over a lot. So there's a lot of decisions to be made. There's a lot of things that need to be done when the first spouse passes away, especially if we don't have an estate plan in place. And so if you are a married couple, it's important that if you haven't done so already, that you get an estate plan in place. It does not have to be complex. It doesn't have to be complicated, but we do want to have an estate plan in place, no matter how simple it may be. If you are a surviving spouse and you need help navigating kind of what to do and how to do it, I'm happy to have a consultation with you to kind of discuss what your needs are. You may or may not need an attorney to help you, but sometimes just having that initial consultation to kind of assess, okay, what do I need to do? How do I go about doing it? And just kind of having a roadmap kind of laid out for you is very helpful. So we have a 1-hour consultation available for you if you would like to do that. So again, I'm Darcel Lobo. I own Dow Law Firm. If you need help with your estate planning, give our office a call. Our number is 206-408-8158. We'd be happy to help you. Again, only if you're in Washington State. I'm only licensed in Washington State. If you are outside of Washington State, again, contact your state bar association to get a referral for an attorney licensed in your state. All right, I hope this helps, and I'll see you in the next one. Thank you. Hi, I'm Darcel Lubbo and I own Dow Law Firm. I'm an attorney in the Seattle area, and today we're talking about non-intervention powers for a personal representative. Also sometimes called a PR, sometimes also called an executor. But this is where someone's passed away, there was a will, probate is being opened, and one of the things, if you are I'm going to call them a PR just for ease for this video, if you are the proposed PR, you want to ensure that you have non-intervention powers. And so let's talk about what that is and why you want to have that. So the PR is the person who's named in a will to administer someone's estate according to the terms of the will. So the person's will says, I, want this to go to person A, this to go to person B, and this to go to person C. Great. However, that is just a set of instructions. So how does that actually happen? How does everything get to person A, B, and C? It does through probate. Probate is a court process where a judge oversees the administration of the estate according to the terms of the will. So the court reviews the will, appoints the PR, the person that you have named in the will, assuming that they are qualified to act as PR. And then the question is, are they going to have full intervention or non-intervention powers? Okay. Most wills, if you had it prepared properly by an attorney, it should say that your PR has non-intervention powers. And so for non-intervention powers, that means your PR can administer your estate. Once probate is opened by the court and your PR receives letters testamentary, they can proceed to liquidate assets, pay debts, make distributions without having to go back to court for every step in the way. So non-intervention powers means the PR, the person who's named in the will and who's been appointed, the person who has letters testamentary, can administer the estate on their own. Okay? If you do not have non-intervention powers, then that means you have full intervention powers. Full intervention powers means the court is going to oversee everything you do every step of the way in a probate, which is kind of a lot. It slows things down. It gets pretty expensive if it's a full intervention, okay? So if you are, filing taxes, selling a house, paying debts, closing out accounts, making distributions, everything that you're doing every step of the way requires a motion and court approval for you to take those actions. Whereas with non-intervention, once you're appointed, when probate's initially opened, you are off and able to administer the estate, and you're gonna give the court a final report at the end of the probate, but you're not having to go back to the court every time you need to do something in the probate. And so, again, most wills which are properly prepared by an attorney are going to provide for non-intervention powers. If there is no will, then it's not going to be such a for sure thing that you'll have non-intervention powers. And so if there is no will, you have to ask the court to give you non-intervention powers. If you are the one or whoever the person is seeking to be named as PR, has to get court approval to be named to have non-intervention powers. And so, if there's multiple heirs, they need to agree. The estate needs to be solvent. You have to prove that there is a valid basis for the court to grant you non-intervention powers as the PR of someone's estate. So, again, with the will, that should already be provided for, so the court will follow the request of the will to have non-intervention powers. But if there's no will, you're going to have to ask the court for consideration to give you non-intervention powers. So that's really the difference, is having to go back to court to get permission every step of the way when you are administering a probate estate for someone. So I hope this is helpful, and I'll see you in the next one. All right, bye. Both wills and trusts will transfer your assets, but they're going to do so in completely different ways. And we're going to go over the real difference between them, and we're going to make it simplified. In today's video, I'm going to break down what each one does, how they're different, and which one might make the most sense for you. I'm Darcel Lobo. I'm an estate planning attorney in the Seattle area. If you're local to the area, I'm in Normandy Park, specifically kind of close to SeaTac Airport. I've been a licensed attorney for over 16 years. And let's get into estate planning and wills and trusts, and let's just demystify them and help you decide what's better for you. Because before we get into the details of it, I want to make sure it's clear that both these options can be great options for most of you. Now, wills versus trusts, they do work differently, but they both work. One is not bad, one is not better than the other. For different clients, a will may be a better fit. For other clients, a trust may be a better fit. And the end result of a will or a trust, we can reach the same goals. Like the end result can be the same. It's just a matter of how are we going to get there? Which vehicle do you want to use to administer your estate? So I want to start with that because sometimes there could be a notion of, a will is bad or a trust is bad. And, different states have different laws. And so in different states, sometimes people do view a trust as more preferable or a will as more preferable. But in Washington State, I don't think that's as true. Probate here is more simplified, it's more streamlined. But let's kind of get into both options so you can decide what's best for you. We're going to start by talking about what is a will. Before we can kind of really compare the pros and cons or a will versus trust, I need to make sure that you understand what a will is and how it works. So a will is going to outline who receives your estate after you've passed away. However, in order for it to take effect, in order for that to actually happen and for your assets to get to your heirs, it has to go through probate. So you'll think of a will as like a set of instructions of what you want to have happen, what the plan is, what the blueprint is for your estate. But in order for it to actually happen, it has to go through a probate, where a probate court and a judge will oversee the administration of your estate according to the terms of your will. So upon your passing, the will gets filed with the court, probate gets opened, your executor is appointed, letters testamentary are issued, and the person that you have named can then go forward, liquidate assets, pay any debts that you have, take care of your final tax returns, and then ultimately make distributions to your heirs. There may be real estate to be sold, vehicles to be sold, things of that nature, and they're able to handle all of that, but through the oversight of a probate court. And at the end of the probate, then the executor is filing a final declaration of completion, itemizing what the assets were, what the debts were, and who received what. So that is what happens with a will. It goes through probate. So let's compare that with a revocable living trust. A revocable living trust is different than a will in that it holds property during your lifetime. So when you create your revocable living trust, the step 2 of creating your trust is putting your assets actually into the trust for the trust to control. During your lifetime, you control the trust, you control the assets, you manage it. Whatever you wanted to do with your property, you want to buy more real estate, you want to sell real estate, you want to rent out real estate, you want to have investments. You can do all those things, but you do so through your trust. And the reason you do it this way is that upon your passing, your successor trustee can then proceed to liquidate assets, pay debts, file your taxes, and make distributions to heirs, but they do so without probate. That is the biggest difference between a will and a revocable living trust. Again, the end result of your estate going to your heirs, that's going to happen in either scenario. Just how are we going to get there? Are we going to get there through probate with a will? Or are we going to get there without probate through a trust? That's the biggest difference. So really I usually see 3 reasons why a client would want a trust over a will if you're trying to decide between the two. One is avoiding probate. right? They don't want their family or heirs having to go through a legal procedure, having to go to court, having to just go through that probate process. Also, second reason, and also is along these same lines, is that they want more privacy. The will and probate are all public record. Anyone could look up the court records and see what your will said, look at the probate, see what your assets were, see what the debts were, see how much your heirs received. That's all public record. With the trust, it's not public record. It's not filed with the court. It's not probate. It's not as public as a will is, so the trust gives you more privacy. And then if you have real estate outside of the state, so let's say you reside here in Washington, but you also have a second home. Usually Arizona is pretty popular for clients. Hawaii is another one. So let's say you have real estate in another state. The trust may make more sense for you because otherwise there'd be a probate here in Washington, but then also in the other state where you have your other property. So if you have real estate here in Washington and Arizona, you could be looking at two probates for your estate, one in Washington state and a second one in Arizona state for that real estate down there. Those are kind of the key reasons as to why I see a client look at a trust over a will. But again, the end result is the same. We can get to the same distributions. It's just how are we going to get there? So which one is right for you? Is a will better for you? Is a trust better for you? So with the will is simpler. The will is more affordable up front. So a will-based estate plan is less expensive than a trust-based plan. The trust has a little bit more to it, it's more complex, there's more drafting involved, so the trust is more expensive. However, with the will option, there will be a probate on the back end upon your passing, right? So when you factor in the will plus the cost of that future probate, that's going to exceed the cost of the trust. And with the trust, again, you're not going to have probate later. So the trust will ultimately be less expensive, but for your initial upfront investment to get your estate plan done, the will is less expensive. And that is a factor, right? As far as the cost of what it is to get your estate plan done. So the will is going to be less, the trust is going to be more for that initial investment into getting your estate plan done. And then also with the trust, there's not a lot of management that you have to do, but you do have to make sure that once we create the trust, and here at our office at Dow Law Firm, we help you with funding it, we get your real estate into it, we take care of that for you. But going forward, if you acquire future real estate, you have to make sure that that future real estate gets into your trust because the trust has to own the asset in order for it to control it upon your passing. And then so that's what the will option looks like. For a trust option, if you're not sure if that's right for you, if you have real estate in more than one state, the trust might be a better option for you. If you want more privacy, if you don't want everyone seeing what your estate included, what your assets were, what your debts were, and how much your heirs received, trust might be a better option for you. If you don't want your family to have to go through probate and that court process and those proceedings, then again, a trust could be better for you. So whether you choose a will or a trust for your estate plan, the most important thing is to just have a plan in place. I tell my clients all the time, that's one of the best gifts you can leave to your family upon your passing is to have a comprehensive estate plan where everything's laid out, you've made all the decisions, everything's outlined for them to just follow. And for a lot of our clients, getting their estate planning done has been on their to-do list for years. For some clients, it's been many years, right? It's been 10 years, 20 years. I have clients where they come in and they'll say, when our kids were born, we wanted to get our estate plan done, and we just never did. And now they're adults. Our kids are grown, and we need to get our estate plan done. And that's okay. We are here to help you get it done. So let's get your estate plan done off of your to-do list, whether you want to do a will, if you want to do a trust, or if you're unsure during our consultation, we'll go over kind of what your wishes are. What do you want? We'll kind of go in detail about the pros and cons of each and help you make that decision. My goal as your estate planning attorney is to make it simpler for you, easier for you to understand, not so overwhelming, because I understand that nobody wants to come in and talk to an attorney that they don't know about what's going to happen when they've passed away. That's not a desirable conversation to have. I fully understand that. We don't, it's natural to not to want to have those conversations, especially with a stranger, right? And sometimes I'm asking questions that maybe things that you haven't thought about before, especially if you have children who are minors, something happens to you, what's going to happen for them? Who's going to be their guardian? Who's going to take care of them and their inheritance, right? These are all questions that might not be the most comfortable to discuss, but they're important conversations for us to have. And so whatever I can do to make it easier for you, we do. And so we offer consultations in person, over Zoom, by phone. We do a lot of things electronically to kind of help make things easier for you when it comes to signing. We take care of all that for you. We prepare a binder for you that has all of your documents, instructions for your family, important resources and information. We do what we can to make it easier for you and your family. Usually the hardest first step is like making that call and having the consultation. Because again, I understand it's uncomfortable, but it's one that's really important that we have. We need to have that conversation. We need to make these decisions and put it in writing and have it signed so you can know that if something were to happen to you, there's a plan in place and it's all taken care of. So if you need help, contact our office. We'll be happy to help you. Our number is 206-408-8158, and I'll see you in the next video. Thanks. Hi, I'm Darcel Lobo. I own Dow Law Firm, and today we're going to answer the question about pour-over wills. What are they? Why do you need them? Why would you have a will if you have a revocable living trust? We're going to go over all of that today. So for a lot of our clients, the estate plan that they choose is a revocable living trust. Now there's a few reasons why a client would want a revocable living trust instead of a will. One is the privacy factor. Wills are all public record. Once they get filed, everyone could see the probate, what the assets are, what the debts are, what the heirs inherited. So privacy is a big reason. Another reason is that they want to keep their estate out of court, right? So with the will, which goes through probate, with the revocable living trust, their estate is not going through probate. And then also a third reason is that if I have a client who owns real estate in multiple states, like outside of Washington state, we're usually looking at a trust to help them avoid probate in each of those states where they have real estate. So that's kind of a short overview as to why someone would select a trust over a will. But let's talk about the pour-over will, because when we prepare a revocable living trust, what also comes along with that is a pour-over will. We prepare that in all of the trusts that our office prepares. We include a pour-over will. Why do we do that? We include a pour-over will primarily for any future real estate. So when we prepare your trust, we are also transferring the real estate that you own into your trust. However, I cannot transfer future real estate that you don't own yet, right? And so one of the things that you need to remember and to keep in mind as you acquire future real estate, if you have a trust, is that you need to get that future real estate into your trust as well. We would do that by preparing a new deed, putting that property into your trust. So we create your trust. If you buy a future piece of real estate, we tell all of our clients, make sure you give us a call, let us know, and we will get that property into your trust as well. However, there are occasions where someone may forget or overlook getting that future real estate into their trust. So let's say you did your trust, let's say you did it now in 2025. Okay, and then let's say 2 years from now, you buy another property and you forget to put that property into the trust that you created back in 2025. That is where the pour-over will comes into play. So what it does is that it catches that additional real estate that you didn't put into your trust and it pours it over into your trust. That's why it's called a pour-over will. It's pouring those assets that you forgot to transfer into your trust for you. But here's the kicker. It can only do so by opening a probate to file that will and to get those assets that you forgot to put into your trust. One of the biggest points as to why we're doing the trust is to avoid probate. So if you acquire future real estate and you don't get it into your trust, there's going to be a probate for that real estate to get it into your trust for you. So what the pour-over will says in short is, whatever assets might not be in my trust, put them in my trust for me. So that's what the pour over will says. That's what it does. That's when you would need it. However, ideally, when we've done a revocable living trust for you, you do not need the pour over will. It is a backup plan. It is something that we don't want to have to use, but we include it just in case, because unfortunately there's too many occasions where a client has forgotten when they've acquired future real estate. So that is kind of the how, the why, the when of a pour over will. But ideally, if you have all your assets in the trust, and we give you those instructions when we complete your trust for you, we do a close in there that kind of details, okay, if you buy future real estate, let us know, we'll get into your trust, things like that. So if you do that, then you will not have a need for that pour over will. There will not be a probate for your estate. It won't be needed. Again, it's a backup plan just in case. We want your trust to control the entire distribution of all of your assets. So the pour over will is just a backup plan, but if you have a revocable living trust, you should also have a pour over will. We do it for all of the trusts that we prepare at our office. If you need help with your estate plan, with a revocable living trust, or with a will, give our office a call. Our number is 206-408-8158. You can also text us at that number as well, and I'll have all that info below for you for how to reach us and our website and things like that. So I hope this is helpful. Again, I'm Darcel Lobo. I'm the owner of Dow Law Firm, and I'll see you in the next video. All right, thank you. Bye. Question for you. When was the last time that you looked at your estate plan? If life has changed since you had it drafted, your plan might need to change also. I'm Darcel Lobo. I'm an estate planning attorney in the Seattle area, have been so for over 16 years now, helping clients with estate planning and with probate. So let's talk about your estate plan and when it's time to update it. Because if you have a will or you have a trust, maybe it's from 5 years ago or 10 years ago, or maybe even longer, how do you know when it's time to update it? In this video, we're going to answer that question. How often should you review your estate plan, and what type of life events mean that it might be time for that update? So first one, let's start off with how often should you review your estate plan? My general rule of thumb is about every 3 to 5 years. You should at least be looking at it and making sure it still reflects what your intentions are, what your wishes are. But outside of that time frame, we should be doing so sooner if there's a major life event in your life or in the lives of anyone who's named in your estate plan. Now, what does that mean? What is a major life event that might require you to update your estate plan? Well, here are some life events that should trigger that we might need to look at your estate plan and make some updates. If you get married or if you get divorced, we probably should be looking at your estate plan to make sure it's still accurate, because it may not be. If there's a birth of a child or an adoption of a child, we might be looking at your estate plan to make sure we make some updates there, right? If your children were minors when you drafted your estate plan and now they're adults, we don't need a guardian anymore, and you might want to change how you've outlined distributions to them, right? Now that they've become adults, maybe there's some spending habits or there's other concerns that we need to think about now that they're adults. So that might require us to at least revisit that distribution and make sure it still reflects what your wishes are when it comes to that distribution. Maybe you've moved to a new state. Now, moving to a new state does not necessarily mean that you have to get a new will or that you have to get a new trust. But you want to make sure that you have it reviewed by an attorney licensed in that new state to make sure that there's something in there that, would be an issue in that new state. So for the most part, when I review out-of-state estate plans, we don't need to do a new will. We don't need to do a new trust just because they've moved, but maybe there are some updates that we need to do. So moving to a new state can be one of those life events that necessitates at least a consultation with an attorney to make sure does everything still look good. If somebody is in your estate plan who has passed away, right, might want to look at some updates to your estate plan in that circumstance. Now, a lot of estate plans that we do, we already name a backup in that situation, right? So maybe you've named John Doe as your power of attorney. But usually in our power of attorneys, we have a backup, an alternate. So if John Doe is unable or unwilling to serve, we have Jane Doe, right? So your documents might already provide for what happens if someone's passed away in your estate plan, but it's a good idea to at least review it and to make sure that no updates are needed because somebody passed away. Also, if you've had kind of significant changes to your finances, to your assets, right? If you have acquired more real estate, if you have acquired more investments, you've had growth in those assets. If you didn't do tax planning when you initially did your estate plan, you might want to consider doing some tax planning to protect your estate from any taxes. At Washington state level, the threshold is $3 million per individual for estate planning purposes for taxes. And so if you have surpassed that number, if you had growth in your assets, that's great. But we might want to look at how can we minimize or eliminate any tax implications from that growth of assets upon your passing. So those are some kind of life events that might trigger, let's at least sit down and review the estate plan and see if we need to make any updates. Now, why do these updates matter? Why do you need to update your estate plan? Well, we want to make sure that we keep your estate plan consistent with what your wishes are and what you want to have happen. That's why you did your estate plan in the first place, was to make sure that what it is that you wanted for your assets and for your family, for your loved ones, that those wishes and distributions are actually happening in the way that you want them to happen. And maybe what you wanted to have happen 10 years ago is not what you want anymore. But we have to actually update that estate plan to make sure it reflects what you want now. Also, we don't want to have any confusion or conflict down the road. That's why you're doing an estate plan, right? We want to eliminate any conflicts down the road among family or our loved ones. And so we want to make sure that our estate plan reflects what it is that we actually want. And we want to make sure your estate plan still works for your current situation and what your current needs are, right? Those things can change as you progress through life. What you need or want when you're in your 20s or 30s versus when you're in your 50s or 60s versus when you're in your 70s or 80s, right? Like those things can change over time, and they usually do. And so we want to make sure that your estate plan is changing as you need it to change and as your wants and desires for your estate changes and as the assets of your estate change. We want to make sure that what you want to have happen is actually what happens. So what do you do next? So you've found your estate plan, you found that will, you found that trust, you've looked it over, and you figured, maybe it's time for me to make some changes here. So what I tell a lot of my clients who have estate plans that we want to update is I don't want you to make changes on your original documents. Don't make changes on those documents directly. But if you have a set of copies of those documents, you can go through and make notes of those changes. I can't tell you in it's been so helpful when someone's come to me and they've had a copy of their will or their trust, and they have gone through and made notes of what names they want to change, what distributions they want to change, what gifts they want to change. That's very helpful for me as your estate planning attorney so that I know exactly, okay, let's talk about these notes you have here, maybe some things you didn't consider. So during our consultation, we can talk about what those changes are, what your objectives are, and how we can make sure that that's fulfilled for you. And so the next step is to schedule a consultation with an estate planning attorney, right? Is to bring your prior documents, either copies or the originals, have the consultation. Again, here at our office, we do them over phone, we do them over Zoom, we do them in person. Whatever is best for you, we're happy to accommodate for that. And then we'll just kind of go through, what do we have in the old estate plan? Maybe what changes do we want to make? And we'll get those done for you. So all in all to say, life is going to change and your estate plan may need to change along with it. And if it's been a number of years since you've reviewed your will, reviewed your trust, it might be time to pull it out, give it a look. And if everything looks great, there's been no changes, great. But if there are some things where you found, I forgot that I left that to so-and-so, or I forgot that I named so-and-so, and that's not going to work anymore for whatever the reason may be, reach out, schedule a consultation. If we're able to assist, we're happy to do so. So our contact information is all listed below for you, our phone number, our website, all that good stuff. Reach out. We're happy to see if we can help you. And if so, we'll schedule that consultation and we'll get those changes done for you. All right, thanks and have a good one. Okay, so you've been meaning to get your estate plan done. You know that you need a will, or maybe you've been considering about a revocable living trust, but you're not sure what's right for you. You've been putting it off. Why not make 2026 the year that you finally get that off of your to-do list? Let's kick off 2026 on the right foot. Take care of a big to-do item that we know we need to do. Let's get it done. I'm Darcel Lobo. I own Dow Law Firm in Normandy Park, which is about 15 minutes south of Seattle in Washington State. Here at my office at Dow Law Firm, my primary goal with estate planning is to make it as easy as possible for you, because I understand that this is a topic that nobody wants to talk about. You don't want to have to come in and talk to a lawyer that you've never met before, tell them all about your assets, your family dynamics, and discuss what's going to happen upon your loss of capacity or upon your passing. I understand that. And so I work to make it as easy as possible for you. Now, I will say there are going to be some difficult decisions that you have to make when it comes to your estate plan, but we need to make those decisions and not have those decisions made for you by someone else who does not know you, who does not know your family. If a judge has to decide these things and follow what state law says will happen, it may not reflect what you want. And I tell my clients all the time that having a well thought out estate plan is really one of the best things that you can do for your family, for your loved ones, to have that plan in place. And I completely understand why you may have been putting off getting your estate plan done. Sometimes people feel like, well, I'm not old enough to have an estate plan. If you're over 18, you're old enough and you need an estate plan. It could be a simple one, maybe it's more complex, depending on what kind of assets you have and what you want to do with your estate plan. But if you're over 18, you need to have something in place. Also, sometimes clients think they don't have enough assets, right? They think, oh, estate planning is only for people who are really wealthy, and I'm not wealthy, so I don't need an estate plan. If you own a house, you need an estate plan. If you have investments, if you have money in the bank, right? If you have assets that you have built and you want to make sure that they go to the right people or to the right charities or whoever you want to leave it to, you need to have an estate plan. It also can just feel really overwhelming, or thoughts about the cost. And I understand that there is a cost, right, when you're hiring a lawyer to do your estate plan. But we're talking about assets that you've built over your career. This can be, if you're in your 20s, your 30s, your 50s, your 70s, right? You have spent a considerable amount of time to build and acquire the assets that you have. We want to make sure that they go to the right people. And we want to make sure that we're doing so in a way that is legally binding and it's going to be enforceable and it's going to be followed. And estate planning, where we are putting that plan in place, we want to make sure that we do it right the first time. Unfortunately, I have seen a lot of do-it-yourself wills and forms have been printed online. And to be fair, I usually see them when they go wrong, right? So there's a will that wasn't completed correctly, right? And so the person may have not have even had a will at that point. And so when we're talking about your home, we're talking about your investments, we're talking about just the assets you've acquired, it is worth the investment to have an estate plan that's done properly. And if you have been putting off your estate plan and kind of kicking that down the road and procrastinating, just know that waiting and delaying to get your estate plan done doesn't make it any easier. It actually makes things more complicated and a bit messier. It's not going to change whether or not you become incapacitated. If that's going to happen, that's going to happen regardless if you have a plan in place or not. It's not going to change when you pass away. When that time comes, it's going to come whether you have a will or have a trust or don't have a plan in place at all, right? So delaying getting your estate plan done isn't going to change the inevitable for your future. And so we want to make sure that we are putting this in place and doing this now while you're able to do so. If you feel like, well, I don't need it now, so it can wait. Well, doing it when you don't need it is the time to be doing it. Waiting until you need an estate plan is too late. If you have lost capacity, you can't sign a power of attorney. You can't sign a will. You can't sign a trust. And what's going to happen in that scenario is that you're probably looking at a guardianship for yourself. And I can tell you firsthand, as an attorney who has handled many a guardianship case, guardianships are very expensive. If you think getting your estate plan done is expensive, a guardianship is 10 times, probably more than 10 times more expensive. And it's very slow. A guardianship, when you need to sell some real estate, takes multiple motions, a number of filings, and you can avoid all of that by having a simple power of attorney. And so I say all this just to stress the importance of having an estate plan, no matter how simple, no matter how complex it may need to be. You need to have a plan in place. You want to leave that for, again, your family, your loved ones, those that you want to provide for, and make sure that the assets that you've acquired are protected. It's time to get your estate plan done. Now, 2026 is January. This is a fresh start, a clean slate, the perfect time to start up the new year, getting that off of your to-do list. Or maybe for some of you, you have an estate plan. Maybe you have a will from 20 years ago. But there's been a number of life changes. You know that there's updates that are needed for your prior will. There's been a number of changes in your life. Maybe there have been, children have been married. There have been divorces. There are more kids. Maybe you have grandkids, right? Like there's been a number of changes that warrant updating your will. Maybe you've acquired more real estate. Maybe you've opened a business. Maybe your asset portfolio has, grown and appreciated, which is amazing. We want to plan for it. We want to provide for it. So if you are in the position where you have a will or a trust from a number of years ago and it needs to be updated, now is the time to do that as well. Because your estate plan should reflect what's going on currently, and not what it was 20 plus years ago, because that probably is not exactly what you want at this point in time in your life. So let's make this year the year that you get your estate plan done, that you get it updated and take care of it. This should be something that's a non-negotiable for you for 2026. There's a lot of information out there for you online to learn more about estate planning and what your options are. I think just here alone on my channel, I think we have over 100 videos now on topics related to estate planning and probate and trusts and all kinds of real estate. And so there's a lot of content here for you, not just on my channel. There's plenty of other attorneys as well for you to kind of get more education about estate planning and what that might look like. I also, on my website, we have a blog. I've been writing this blog bi-weekly for about 6 years now. There's a lot of content there about estate planning and, again, related topics pertaining to estate planning to help you answer some of those questions, take out some of the overwhelm, and just kind of explain estate planning and for you to become more informed about what you may want or what you may need for your estate plan. I kind of have like a 5-step estate planning process at my firm. And actually, I'll make sure it's linked down below. But on my website, I have a free PDF guide that covers estate planning. It's completely free. You don't have to give me your email or sign up for an email list to get it. You just go to the website and just one click and it opens up for you, covering a number of things about estate planning, some FAQs, current pricing, what to expect. But the 5-step process at my office for estate planning is first, we have a consultation. We can do it by phone, we can do it by Zoom, or we can do it in person at my office, whatever is more convenient for you. So that's step 1, is let's just meet and talk about what your wants and needs are. Step 2, I start drafting. We start drafting your estate plan. If it's a will plan, if it's a trust plan, we start drafting that for you. Then a few weeks later, we have your drafts ready for you to review. I have a secure online portal you can use to review the drafts online. I can mail hard copies for you if that's easier for you to review it that way. So you review those drafts, make sure that everything looks good. Once you confirm for us that everything looks great, we schedule a day and time for you to come to our office and we sign your estate plan. We provide the witness and notary at the office, so you just show up with your ID and we get everything signed and executed for you. And then the last step is my delivery of the binder to you. You can pick up your binder at my office or I can mail it to you. And your estate planning binder has all of your original documents, plus instructions for your loved ones or anyone administering your estate as far as what to do, important resources. It's a very thorough binder for you to have. You keep that in your possession. You keep all of your originals. I do not keep them. I keep copies, but not your originals. You have those in your possession. And so that 5-step process takes us through the entire estate plan for yourself to get that completed. So again, with getting your estate plan done, I think the biggest thing that I find from my clients that it really gives them peace of mind and knowing that the assets are protected, there's a plan in place, their family is protected, and the assets that they have worked hard to build and acquire over their lifetimes is going to be distributed how they want it distributed. And if there is, during their lifetime, any competency issues, that they have named someone that they know and trust to be able to make decisions for them when it comes to things like doing their banking for them, right? Paying bills for them, accessing bank accounts, and also like healthcare decisions, being able to communicate with your doctors, get access to health records, knowing that you already have those documents in place. So that if something were to happen to you and you could not make decisions for yourself, you have a plan of action as far as who is going to be in charge if that were to occur. Again, this is one of the best things and one of the best gifts you can leave to your loved ones, to your family, is to have this plan in place. So again, if 2026 is the year that you want to get this off of your to-do plate or your to-do list, get it off the plate and get that completed, reach out to our office. Contact information is listed below for you. We'd be happy to schedule a consultation to see if we can help you and then get your estate plan done for you. Again, our contact information is below. If you're looking for more information about estate planning, about probate, about real estate, make sure you subscribe. We talk about that and many more things over on this channel. So, all right, thank you, and I'll see you in the next one.